Hello dear friends, welcome back on our YouTube channel Indus Lex, and we are going to discuss the salient features of the Indian Constitution. Dear friends, when we say Constitution, it means a set of rules which has legal sanctity and supreme law of that particular land or that particular state. Constitution is a set of rules which governs the different organization of that state. Constitution is a set of rules which govern and interact between the various organization of states and their employees, their other stakeholders. In the present day, when we talk about the constitution or law, it is not same as in the ancient period or in early age of civilization. It gradually developed from customary laws to today's modern law, and after the various liberal movements take place inspired by Magna Carta to French Revolution, the today's democracy or a parliamentary form of government we see. Every state has some sort of arrangement by which that particular state is doing business with other international entities. As we look around ourselves, we have several neighbors, friends, enemies. In the same ratio and in the same aspects, the Indian nation is not in a vacuum. It has several nations, immediate nations like Nepal, Pakistan, Bhutan, Sri Lanka, Bangladesh, Afghanistan. It has relation with several big countries like Russia, United States of America, with Canada also. It is depends upon the market, the power and global order, global business. It depends upon your demography, your economy of that nation, to which you have to favor, or you have some different sort of policy that you belongs to non-allied camp where you don't participate in any other organization, such as India is a Commonwealth member. It is a member of BRICS nation. It is a member of United Nations. So every nation is a different type of government, different type of rule to be governed. But at larger extent, there are two form of government. One government is a parliamentary form of democracy or presidential form of democracy, and other is some communist states. But every state has some authority, has authority at a very core that is very supreme. Maybe that person, that leader whose command is sovereign, or maybe a set of laws that is in the form of constitution, in the form of a living organic document which govern the country. As we are discussing the salient feature of Constitution of India, so we have to understand before the existence of Indian Constitution, there are a few constitution upon which Indian lawmaker, our constitution makers rely upon, such as Constitution of America, Constitution of Canada, Constitution of Australia, Ireland, maybe Britain. Almost Government of India Act 1935 was there. Our constitution is a very lengthy constitution. It is the longest written constitution, and our framers pick some sort of materials, some sort of parts, such as fundamental rights is taken from some country, residuary power of union taken from such other country, single citizenship is taken from other countries, judicial review from some country, meaning thereby our constitution deals with almost every premier organization of the state. On other hand, the Constitution of America, Canada, Ireland, they are very specific in the form of the constitution, because it depends upon the arrangements when that constitution is born, or that constitution of that particular nation. Because when we see the United States of America, that United States of America means there are several states who united and make a United States. However, when we see in India is a union of states, here state is majorly for administrative purpose. And when we see the dominance or try to check the value or existence of the state in the term of Article 3, state are totally depend on the mercy, we can say, of the center. If center notifies, center amends, that the center has power, that the union has a power to alienate the any boundary of the nation, any boundary of the union or the boundary of the states. Union may alter a state into two union territories, in two other states. So the federalism is the aspect on which you can judge how the constitution is. When we talk about the constitution and try to understand what is the characteristics of the constitution, we have to understand that what the constitution deals with, what is the subject matter, what is the main principle over which we can understand or define the constitution. So we can say, we can categorize the constitution whether the constitution is written or unwritten. So at this stage we can say the constitution of England, or we can say Britain, is unwritten, where the constitution of America, India, is written. Then the other term which is very important on which you judge the structure of the constitution is the term federalism. The federalism shows another very important principle of the governance is separation of power. And how the separation of power is judged? It is judged by the rule of law. And how the rule of law will be checked? It will be checked by the independent judiciary and judicial review, power of judicial review. So when we try to understand the structure of the constitution, we have to understand on which parameter we are going to understand or check whether the constitution is good or bad, or whether what is the characteristics of the constitution. We can't say that the constitution is 1 kg and constitution of America is 2 kg. So it is checked on the certain perspective is whether the constitution of India is a federal, Indian state in its character is a federal. What actually constitution does? What actually we have to understand that the Indian constitution is drafted in a very smart way. When there are several examples of the constitution, India has its own problems to deal with for the purpose of the constitution, in making its constitution in such a circumstances in which India is just come up with the era of independence, where his independence is very newly fruit, where India is trying to make a rule which is useful for that time and cope up those problems. India has its own several problems and several minang caused by the separation by the Britishers, and therefore our constitution makers read almost every document, every constitution of that times, and it was a very Herculean task they performed and carve out the important pieces which very evidently efficient to cope up with the problem of Indian people. So when we study the characteristics of the constitution, it is very important to understand the first principle on which the constitution can be judged, that is federalism. Of whom federalism? When we say the constitution is a federal, it means that the structure it makes, organization it creates, such as center and state relation, separation of power between center and state, separation of power between state and judiciary, how much the judiciary is efficient to perform, efficient to do its work in very independent manner, because it have to understand that executive is the wing of the government, you can say, which is a transulent in its nature. It is overlapped by some part of legislature and some function of judiciary. Indian state has 3 wings. Constitution of India makes 3-layer system: state and union, and further a panchayati elections, a panchayati or a local level administration, municipal corporation, etc. Even it also makes separation of power between legislature, executive and judiciary. Legislature who makes law, executive who execute them and also deals with day-to-day businesses, and further the judiciary. But we have to understand that judiciary is also depends on some function of the executive, or there is some interplay relation which sometimes very essential, sometimes very, we can say, very normal situation, where it is a constitution itself says that it must be like that. The Chief Justice of India takes oath in front of President of India. It is a mandatory ceremony, we can say, which has to be followed. Further, if we take a small level example, we can say that the judiciary has no power to enforce its, no power in terms of man to enforce its decree or any order. Suppose that order of arrest, court only can issue warrant. It is the executive who has to perform, who has to execute. So there is some executive function of even of the court. Even the courts work there is some executive function which the court has to perform. Means executive is the very vital wing, and there is an interplay. Suppose that how the judge will be appointed. Definitely would be appointed by some type of commission, or there is a collegium system which has to be appointed, by which judges has to be elected by the collegium system of the Supreme Court. But even that will be finalized by the president, who is the head of the executive. So there is vast interaction between the executive wing and the judiciary. But when we test whether the constitution is an independent judiciary, constitution creates several organization. Constitution creates organization for selection of public service commission is there in the constitution. Even for free and fair election, which is also a very vital and essential necessity of the modern democracy to be successful, or for a true democracy, what we expect is a free and fair election. So our constitution also provides a separate commission, that is the election commission. The Constitution of India is something quasi-federal, or we can say it is not nor the federal nor the unitary government. It has characteristic of the federalism. Then we see that our constitution provides fundamental rights to the citizens. Fundamental rights is guaranteed under part 3rd. And with the power of judicial review, the court must certain that legislature or executive can't act or make a law which is in the violation of the fundamental rights. And if it is so, aggrieved person can approach the Honorable High Court under Article 226 of the Constitution or Article 32 of the Constitution directly to the Supreme Court, and the court may declare that act null and void. This is a power of judicial review. This is how the judiciary review the act done by the legislature or executive. So it is necessary that the citizen must be vigilant also, and must choose a government who work on the free legal aid and continuously trying to enhance this type of mechanism. However, Honorable Supreme Court and High Court also initiates several free legal aid programs. Apart from that, separation of power. How much power is centralized or it is vested in state? So when we see the state has very limited power. Further, if we see the condition of state, the representation is depend upon the population of the region. And suppose that some state who is performing well in the population control, they will face some sort of politically disadvantaged position, because they are population controlled people. They control their population in the interest of nation. It enhance our capacity and reach at such stage which is very beneficial. We can say it is a dividend for us. And now when the process of delimitation in the future, when the representation is decided on the basis of a population, it will cause some sort of dissatisfaction that their representation will be decreased further. Meaning thereby, states like Sikkim, Manipur, Goa, Odisha, Kerala, where population is less, presently they also has some less representation compared to the northern state of like West Bengal, Bihar, Maharashtra, Madhya Pradesh, Uttar Pradesh. Their representation is very high compared to these states. So the particular policy making, fund allotments, they fail to get their dues and benefits. And when in the future the representation will be decided again on the basis of population, definitely southern state has to suffer in term of political advantage. And on this aspect, if we see the federalism of United States of America, you will find that in US Senate, every state has equal representation. Although we have chosen the concept of judicial review from the Constitution of United States of America, we not choose this way of representation where state has equal representation in the US Senate. However, in Rajya Sabha, we give representation on the basis of population. So in term of background, we judge one is federalism, second is separation of power, third is rule of law. Because without the rule of law, actually the constitution is also like a monarch who is at the power. So the concept of constitutionalism is to be there, and this is rule of law is something like absent of arbitrariness. The rule, so the important thing is the rule of law, independent judiciary, further power of judicial review to protect the fundamental rights. Further, Indian constitution provides directives to the union, to the states, whether it is union or state legislature, to make law, to make policy in these directions. So, and further the free and fair election, Indian constitution provides election commission, and we adopt adult franchise, meaning thereby if a person is of sound mind and attained the age of majority, that is 18 plus, he can vote, he has right to vote. So silent feature of the Indian constitution: federalism, free and fair election, independent judiciary with power of judicial review, rule of law, adult franchise, fundamental rights, directive principles, and citizenship is also an important issue to which the Indian constitution deals in part 2 of the Indian constitution from article 5 to 11, in which it's mentioned that in article 11 that the union has power to make law regards to the citizenship. However, from article 5 to 10, it describes the who will be the citizen at the time of the commencement of the Constitution of India. Then Indian constitution set up a democratic setup in which at the top independent judiciary, Supreme Court, Indian Parliament, President, Lok Sabha, Rajya Sabha, and this would be governed by parliamentary form of democracy, in which the majority, party of majority who won the majority in the election, choose its leader as the executive head, and under his command the cabinet of ministers will be appointed. This cabinet of ministers and that leader form called executive, head of executive, and that is government. Apart from them, all the winning member is a member of legislature, and judiciary is a separate entity. In Indian democracy, selection of judges is also an interesting issue to discuss, but today it is governed what we know as a collegium system, in which judges choose the judges, and it is the best system, at least till now, to which human mind reached, because there are certain intricacies in which the common citizen or other stakeholder cannot understand, but for the ultimate independence of the judiciary, it is necessary that judges appoint judges, but yes, under the rule of law, where there is no arbitrariness. Further, Indian constitution provides some special arrangements for special institutions like that Public Service Commission, Panchayati Raj, municipal corporation, and then it describes the class of subject on which the union can make law, state can make law, concurrent list on which state and union both can make law. But how it shows that again that the Indian state lacks federalism is that if the union makes law on the concurrent list, on the subject of concurrent list, that the union law will prevail. Further, the residuary power kept with the union list. So it shows that the state has only administrative unit in the context of India. So our constitution is a need of modernity, is a need of our problem, and we have adopted such form of government, which is a parliamentary form of government. We don't choose the presidential form of the government. We can't choose both of them. We have to opt for at least one. We have chosen the parliamentary form of government. We have chosen a quasi-federal body, quasi-federal relationship where center has more power compared to the states. Then rule of law, separation of power, and independent judiciary with the power of judicial review. We uphold it, and in this manner, and further, it also consists fundamental rights, directive principles, describe who will be the citizens of India, also make arrangements of several institutions who make sure the proper separation of power, fair election. So in the term of constitution, it is a almost perfect constitution which we get from our foundation, our founding father, and always thank them for this masterpiece. Thank you.